Okay, ladies and gentlemen, if there's no more public comment, we will go to summation rebuttal by appellant. Do you have anything further to say on the summation? Mr. and Mrs. Snowden?
I'd just like to say that Ken is trying to be here. He had intentions of being here. His schedule is, he's just a busy guy, and he's in Lodi trying to get here, and I don't know that we really, that he's going to change much. You've heard what we have to say, and we are telling the truth, and whether or not that film comes into play, I'd respect your decision however it goes. Thank you.
Thank you, sir. Mr. Maurer, staff summation and rebuttal?
I have nothing more to add. I guess, well, except for the one point, the issue has been brought up about the loss of the lack of record keeping of the list, and it's unfortunate. We've looked high and low throughout our whole department trying to see if it's where it might have gone. Don't know. It may have just been inadvertently discarded when we were done with the list, stuffed away in some file someplace. But we have tried very hard to find that list. We cannot do that. So unfortunately, we do not have the record to show one way or the other. There were several different lists being made during the time. One was a list of people sort of standing in line that you could come in and say, well, you don't have to stand there. We'll give you a call, sometime later today to come in. Then we started creating a different list. There were multiple lists going on at different times. We were just trying to adjust as as best we thought possible during that rush period over the last several days. Again, I cannot say for certainty one way or the other whether or not she signed up, and if she signed up what list it was on, because we just simply cannot find where those lists might have been, or if they've been discarded. So the issue, I guess, before you was whether or not there was a good faith effort made to submit the application, and whether or not we should continue to accept it and then process it, or whether, as the commission found, or the strict interpretation of the code was that you had to submit. There was no record of any submittal, and therefore they could not find that could overturn my decision not to accept the late application.
Okay, thank you. Any rebuttal by the public, members of the public?
I believe the only thing that it was rejected for was because it wasn't by the June 30th date, correct? And I was there on June 30th to submit everything. Ken Foley had tried to subpoena for the list from the planning department and the sheriff's department, and apparently nothing has come of that. But he also did put something in the paper regarding people that were at the courthouse that day, on the last day, and if anybody had signed some paperwork and were under the same impression that I was going to be called. And there are people. There was Channel 10 News there. It's just a matter of subpoenaing them, getting them in here to tell you that, yes, there was, I'm not lying, there was a list. I signed the list. It was, I honestly thought I would be called. I thought that was the list you had to sign. And I thought I was okay because I had signed that, and it was on June 30th, and I was okay.
Thank you.
I can't tell you anything else. Okay. I tried.
All right, we'll bring it back to the board. Any questions? This time we're going to close the hearing. We'll have Board discussion, deliberation? Anybody want to speak first?
I'm dragging it here.
Supervisor Mills, floor is yours.
I refer to 1795.165, and in legal terms, there's two terms, and I know council understands this. There's the may and the shall. One is an option, the other one is you must. In the case of submitting an application, a complete application, it says shall. There are other sections of the urgency ordinance says that you must also submit your appropriate amount of money as well at that time. Signing a list on June 30th or any other date wasn't part of 1795 as an ordinance, nor was an option to make a payment later. But we're finding now that much of this information and the application itself was turned in long after the deadline had passed. So I know the things that were not discussed, because I go back, I just spoke with Mr. Maurer about some of those things that are on that presentation you gave us, that there are some things on that presentation by themselves have been reasons that we have rejected applications, such as no fence, no gate, no posting of the application on the site. None of that seems to be part of the discussion, so it isn't part of the discussion today. Today, the discussion is, did we or did we not? And I do not see sufficient evidence here to indicate that the intent of 1795.165N1 has been met.
Thank you, Supervisor Mills. Further deliberation by the board? Supervisor Garamendi.
You know, I'm not an attorney. I'm not a judge. It's generally, I don't think many of us anticipated we'd be in these type of situations often. But, I try to do things fair and equitably. And I think that, I've been trying very hard to apply the urgency ordinance equitably. It doesn't mean it's always fair. My heart breaks for you and all that you've had to go through, and I'm sorry for that. But if we're going to be equitable, and then I have to go with that the application wasn't turned in until a year later. And I'm not saying that's fair or good, and I'm sure I'll answer for it at some point, but I'm sorry.
Supervisor Tofinelli.
Yeah, this is a tough. The one thing that sticks with me though is all the people that spoke that are permitted growers and went through the application process or still going through the application process. Obviously know you, and they were doing the same process, and to wait a year to then come forward, it just, something's not, if it was the next day or 2 days later, I didn't get a phone call or something, it might be viable in my mind, what you're saying, and I know you were going through some troubling times, but a year later, to show up and say, here's my application, just the delay in time is just beyond something that I can see past, and we've denied on less than that many times. So I just can't see. I'm sorry. I really am. The year just is too long. It just took too long.
Folks, this is a board deliberation time, unfortunately. We can only have our board members address these issues. I too feel sorry. I know the trauma of going through a situation, a very serious injury on motorcycle accidents, but also, in all fairness, it applies to all. I actually share the concerns my fellow supervisors do. I do not find there's good cause to continue the matter. and I would vote to deny the appeal by the applicant. Having said that, do I hear a motion? Oh, I'm sorry.
Just for clarification of the record, I did hear what Chair Oliveira just said. I know that there was a polling on whether to grant or deny the request for continuance. For the record, I would recommend that the remainder of the board members identify why there was a no good cause for continuance and the reason for why you denied the request for continuance, just to keep the record straight. I do recommend that.
Thank you, counsel. Before entertaining a motion, I would like to address that situation. We'll start with Supervisor Tofinelli. Comments?
Why we denied the continuance. I didn't think it was going to do any good, and the fact that what was in the letter by Mr. Foley had to do with new evidence, and it didn't seem to be relevant to me as to continuing it.
Supervisor Garamendi?
I concur with Supervisor Tofinelli.
Supervisor Mills?
I would concur as well. I believe I would concur as well. I believe that it is the responsibility of counsel, if he's not available, to find alternate counsel for assistance and not leave his clients hanging.
Thank you. I also concur with Supervisor Mills and Supervisor Tofinelli. I have seen in court proceedings where substitute attorneys were making appearances for conflict and scheduling, and I feel in this particular circumstance that probably would have been a good way to go. But I feel that there's not enough evidence to warrant a continuance based on that statement. Now, let's go back to the issue at hand. Deliberation is over. I'll entertain a motion.
I would move to uphold the Planning Commission's denial.
I will second that.
Motion by Supervisor Tofinelli, seconded by Supervisor Mills. No further public discussion. All in favor indicate by saying aye.
Aye.
Opposed indicate by saying no. Hearing none, motion passes 4-0 and 1 abstention. You can have that moment, Madam Clerk. Mr. Snowden, the matter's been voted on, decided. No, sir. I'm afraid. No, sir. Madam Clerk?
Item 28 is from the Planning Department to conduct a public hearing and adopt a resolution upholding the Planning Commission's denial of the appeal of the Planning Director's denial of commercial cannabis registration 2016-654 for Norman Gunsel and Amy Volpe Gunsel at a site located on the west side of Adobe Gulch Road, approximately 1/2 mile north of the intersection of Cave City Road and Adobe Gulch Road, Mountain Ranch, APN 036-031-017.
Ladies and gentlemen, this will be a public hearing. I'll open the hearing. Mr. Mauer.
We have had a verbal request for continuance on this item as well, and for the purpose of considering the request, I would like to discuss the next two items as well. The applicant or the appellant on all three items are the same. The representative attorney is the same. She has indicated that she is out of town and would not be able to attend. And so it's requested a continuance. I informed her that she would need to submit that in writing to you. I don't know if she did that or not. I did not receive anything. That the decision to continue would be up to this board rather than my decision. So I recommend a bifurcated, joined, I don't know how you would describe it, to address the continuance request on all 3 items, but just consider the continuance request first, if that makes any sense.
It does make sense, Mr. Mauer, but we would have to vote individual on each agendized item, although the information presented could apply to all 3 generally.
As far as the continuance is concerned.
That's correct.
Each individual appeal is based on separate reasons for the original denial.
Okay. Is the appellant present? Okay. Thank you, sir.
Yes, good
Now,
evening.
sir, we're only going to talk about the reasons for a continuance.
Okay,
We'll go into individual facts if we have to.
All right.
On each agendized item and location.
right.
All right. Could you address the reason for the request of continuance?
My attorney, who's very much involved in this case, prepared a statement for me to read. I'd like to continue it. My name is Norman Gunsel, and my wife and I own property that is the subject of this appeal and the next 2 appeals. If I may add at this point, she indicated to me that she sent an email to each of the Board of Supervisors explaining why she couldn't be here. She sent this in an email on August 10th with proof that she had already purchased plane tickets and details about where she was going and why, which she requested to remain not in the public record. But having added that, my attorney sent a timely request to have these matters continued because she is out of town on a pre-planned trip. A copy of her flights was attached to that request. My appeals are complicated, and I am not comfortable proceeding forward without her. I am requesting that the board grant us a continuance to the next available hearing so that she can be present and present out our case. And I really don't like to use other people's words, but she instructed me quite strongly that I read that statement. I have more that I also could read if necessary, but I hope that that's reason enough to give us a continuance. I thank you.
Mr. Chair, I would like to confirm that, yes, the email was received and forwarded to the Board of Supervisors and the Planning Department on August 10th.
Okay. Thank you, Madam Clerk. Thank you, sir. Gentlemen, we're going to be addressing the issue of a continuance right now. Any comment by the board?
I would be for continuing all 3 of them. You know, we've been here for 11 hours now. I'm not like an endurance racer. And so, you know, I'd be for that and get on with the one remaining and stuff. We'll still be here probably past 8. That's what my thoughts are.
Supervisor Mills?
I think at some point, attorneys who are representing people, appellants before this board, would take the responsibility to ensure that they had alternate counsel or alternate assistants of counsel present, especially when they know they're going to not be available. They plan to not be available. They could certainly plan to represent their clients by finding someone to help them. It's just baffling, the continual effort by some of the attorneys to delay or postpone these hearings and not allow it to move forward in a timely manner.
Supervisor Tofinelli?
I'd have to agree with Supervisor Mills.
Supervisor Garamendi?
I agree with Supervisor Mills and Supervisor Tofinelli on this.
Okay.
Let's go.
Do I get to vote?
Yes.
I do not find this good cause to continue this matter because in my profession as a consultant, when I have a court date, testify, I make arrangements. There was one time I actually flew back from Boston to honor that court date. I agree with my fellow supervisors that I would not agree to this continuance. Do we need a vote on that, council?
Because it is a formal request for continuance, I do recommend that there be either a poll or a motion and a vote on whether you grant the continuance or not.
Okay. I'd entertain a motion.
No, it's a poll.
No, I'd entertain a motion. Anybody want to make a motion as to the continuance issue?
I would move we hear the matter today.
It's been moved.
I would second.
Moved by Supervisor Mills, seconded by Supervisor Tofinelli. Public comment? Seeing none, bring it back to the board for a vote. All in favor of denying the continuance indicate by saying aye. Aye. Opposed indicate by saying no. Hearing none, the vote for denying the continuance is favorable by 5-0, unanimous.
Okay, we'll go forward then with the appeal of item 2016-654, Norman Gunsel and Amy Volpe Gunsel. This is a denial of an appeal of the planning department's denial of the cannabis cultivation. And the finding was that the applicant did not produce evidence that no later than May 10, 2016, the cultivation, grading, or earth moving commensurate with the area proposed to be developed had occurred on the site. Location is at the end of Adobe Gulch Road in the Mountain Ranch area. There are 4 separate applications for cultivation that were filed by the Gunsels. We're talking about the one on the right, 654 in red. This is an aerial taken on June 9th, 2016, and there is no evidence of cultivation on the site at that point in time. This is the application site plan that showed 22,000 square feet of grow in approximately the center of the parcel. Again, going back, no sign of cultivation there. These were the photographs that were submitted, dated May 2nd, and March 26th, and May 1st of 2016, clearly showing an area of cultivation, plastic sheeting to protect it, protect the plants probably from frost, young plants on the right-hand side. And again, if you look at the aerial image down below, there's no sign of any of that information. So we felt that that failed to meet the requirements of N3 of submittal of photographic evidence showing cultivation commensurate with the 22,000 square feet of cultivation area submitted with the application. Another photograph submitted showed large mature plants. This was taken or dated August 21st of 2015. Again, no evidence that that had occurred previously on the site. So, moving quickly through that, we felt also that the photos that were submitted were false and misleading because they were representing that cultivation had occurred, 22,000 square feet of cultivation had occurred on the site, when clearly they didn't. And so our only conclusion was that these photographs were intended to misrepresent to the county what was going on the site.
If I could...
You'll get a chance to
All right.
respond. In their appeal letter, they stated that the parcel was planted and cultivated in prior years, that had remained fallow for the last couple of years, and that the cannabis was grown back in the woods so you couldn't see it, and that the photographs were not false or misleading. In fact, that there was a mix-up somewhere that the wrong photographs were submitted with this application. I think that the appellant believed that the county somehow mixed them up. We disagree with that. We think that perhaps the applicant got the photographs mixed up. Regardless, the 3 photographs that were submitted previously were supposed to apply to a different parcel, and the only photograph that was supposed to be with this application was the one larger picture with Mr. Gunsel and the mature plant. I don't know that it really matters as far as the reason for denial. Perhaps the false and misleading. I believe that the Planning Commission, when they denied the application, they removed that finding from the resolution. But the primary reason for denial was the fact that there wasn't 22,000 square feet of cultivation in the area shown on the application, as demonstrated by the aerial imaging. I don't know that I need to go through all of these points here. This was in the record, but this was sort of a discussion of what went on during the hearing regarding whether the county mixed up the pictures or whether it was the appellant that might have mixed up the pictures. No way to tell. Regardless, there were photographs that were in our files that we believe were submitted to support their application, and we believe that they do not support the application. Mr. Gunsel claimed, or his attorney claimed, that there had been guerrilla grows under the trees for years, wanted to be open and forthright with the county. So he didn't take photos of the trees underneath, or plants underneath the trees. But again, the plot plan depicts 22,000 square feet of cultivation in the middle of the parcel with little tree cover. Clearly that was not happening, and the purpose of the urgency ordinance was to freeze cultivation on May 10th, so that no more land was to be disturbed for expansion or new cultivation. And so if he had grown under the trees, then he could continue to grow under the trees, but not a full new 22,000 square foot cultivation area in the middle of the property that had not been previously cultivated upon. So the commission found that they denied the appeal based on the one finding that they failed to provide photographic evidence, demonstrable steps in developing 22,000 square feet of cultivation area, but also found that they did not purposely provide false and misleading information that they might have inadvertently mixed up those photographs. So our recommendation is that you adopt a resolution to uphold the Planning Commission's denial of the appeal of the Planning Director's denial of commercial cannabis registration 2016-654 for Norman Gunsel and Amy Volpe Gunsel at the identified site based on the Planning Commission's resolution. Do you have any questions?
Thank you. Mr. Mauer, Madam Clerk, just for clarification, we are discussing item number 28 on the regular agenda, and that is APN 036-031-017, an address on Adobe Gulch Road, approximately 1/2 mile north of the intersection of Case City Road and Adobe Gulch Road in Mountain Ranch.
That's correct.
Okay. Sir, you may speak as an appellant.
Okay. Again, my attorney has prepared this statement for me. I would like to read it as quickly as I could of the 10 points.
You can, sir.
If I could state at this point, these are all issues that I've talked to my attorney about. She was highly prepared. I'm really sorry she's not here. I'm very disappointed in her myself. But that aside, if I could read these points and have them in the record, please.
You can, sir. I
would like to read the following into the record to preserve the issues. Generally, the three applications should all have the same record and should have been considered together, given the locality of the property. I am a longtime resident in the county and an organic farmer and have practiced crop rotation on my parcels for well over 20 years. Part of the plants that I cultivate include medicinal cannabis. I object to the findings in the staff report on the following grounds. Number one, that the appeal hearing before the Board of Supervisors is not a fair hearing before an impartial tribunal from prejudicial abuses of discretion. This is based on the various comments made by the board members in the media and in public hearings and their personal prejudice on cannabis. Number two, the urgency ordinance as it applies to this petitioner is unconstitutional as it has no rational basis for disproportionate treatment of similarly situated parties, which is a violation of the California Constitution and the federal Constitution. Number three, it is a violation of equal protection in that the county is treating code violations as a basis for denial of the application, despite the fact that any alleged code violations took place a significant time after the application was submitted. Number four, the denial of the continuance is a violation of the due process of my rights because I do not have adequate representation to protect my interest or to exhaust my remedies in a manner that would be productive. Number five, there is a violation of due process because county counsel represents both the prosecutorial side and the judicial side of the hearing with no meaningful separation between members of the same, quote, law firm, county counsel. Number six, the denial of the request to remand to the Planning Commission to consider further information that was not available at the time of the application processing is without proper findings and a violation of due process. Number seven, the county has violated the Permit Streamlining Act by failing to process the application in a timely manner and failing to allow reasonable time to correct any inconsistencies or errors in the application. Number eight, the findings of the Planning Commission and the proposed findings of the Board of Supervisors are insufficient and therefore a violation of the due process rights. Number nine, the administrative record is inaccurate in the photos used for one application have been used by the staff in their reports for the wrong applications, thereby cross-mingling the three applications. Number 10, all other objections and issues that were presented at the Planning Commission are requested to be entered into the record for this hearing as well. Thank you.
Sir, I have a question. Do you intend to present that same evidence you just related on all three issues?
Yes.
Okay. Counsel, for the purpose, can we consider that evidence when we get to those evidence items? Or do we need to read them back into the record?
For the record, the cleanest way is to have it read in. However, he can submit the comments in writing, and that would certainly be part of the record in any subsequent hearing.
Sir, how many copies do you have?
I just have one here.
Okay, let's take a short break. Madam Clerk, can you assist with making copies? And we're going to need copies for the two remaining items. Okay, ladies and gentlemen, we're back in session. Okay. Would the appellant please approach the podium? Sir, at this time, would you like to respond other than the statement you just read from your attorney regarding the issues presented by Mr. Mauer?
Well, if If I could, I'd like to say that my attorney advised me not to go in any detail of these things. As I said, she has all the materials, all these points. As you're going through them, I remember talking to her about them and talking to her about her strategy as to how to address all these issues. I am not prepared for this at all. She has all my materials. Be truthful with you, I'm absolutely exhausted. My wife and I have been here since 8 o'clock this morning, and I understand all you have too. You probably feel pretty much the same way I do. I might be able to help you to some degree, but I feel very inadequate to answer probably most of this, but I could be of assistance in whatever way I can.
You understand that this is the actual hearing,
Right.
and we're going to make a decision on the information.
Yes.
Let me finish, please, sir.
Okay.
On the information provided here, now. So I want to make sure you understand that, so you have the opportunity to present your case. And I understand your desire to wait for your attorney. But the fact of the matter is that we did not actually issue a continuance, so we're going to hear this case tonight. Okay? Do you understand that, sir?
I understand.
Okay. Good. Do you have anything further to say?
On what was shown here, the first time I saw these pictures that were supposed to be what I offered as evidence of my history of growing on that particular parcel, I was shocked. I said, "What are these photos doing here? They don't belong there. They're supposed to be in another file." I would not submit a picture that wasn't truthful. I mean, there it is right there. That's not on the parcel that we're talking about. And as far as cultivation of over 22,000 square feet on that parcel that has been certified organic, registered as a certified organic garden through CCOF. We've been certified organic since 2001. We have plenty of history of that parcel being inspected as a garden, not only by CCOF and representatives of USDA, but also by the county, who would come out every year. We grew vegetables there starting probably 19 years ago, and provided produce for the local farmers markets, and also our farm to kitchen restaurant that we ran for 10 years. So there's a long history of that field being gardened. In the evidence that my attorney also has is an article that was done on me in the Union Democrat probably 12 years ago. Has a picture of me standing in that exact garden, and that's also with my attorney. Part of organic certification is that I use crop rotation. Crop rotation is a very important part of our organic system plan, and this field has been fallow for at least a few years, and that's really good for ground. We also garden on the other field, which I assume we're going to be discussing, and that has been cultivated more recently. Like I said, if I can easily show documentation. My attorney has documentation of that field being cultivated. I can't tell you exactly when, but it was a few years ago.
Sir, this young lady is your wife?
Yes.
Okay. Mr. Mauer, the names on the application, do they include both individuals' names or just one name?
Both names.
Okay. Ma'am, You are going to be considered an appellant, so you have the right to speak. Is there something that you'd like to add at this time?
No. We're all really tired, sorry.
I've been here since
been a
8
long
o'clock
day,
this
sir.
morning. I'm really hot, and
Speak into the mic.
what would you like me to add?
Anything you desire, ma'am. This is the appellate's time to speak in regards to the presentation made by staff.
Well, I met my husband in 1994. Married him in 1999. And I've never met a more devoted steward of the land than this guy right here. He's a very devoted community member. We are devoted to what we do. We've been raising certified organic produce now for the better part of 2 decades. And 2 decades we've been doing this. Service to our community, service to the... We're good stewards. We're good stewards.
Thank you.
And that's what we are. And if anybody deserves a chance to make a living on their land, we've been trying for an awful long time to make a living, and it's pretty hard. So this opportunity came up, and we thought that we would take it and hope that it would have a good effect on our community and our own lives. And we need a chance to do this because we have not been able to succeed in ways that we would like to succeed. So this seemed to be a good chance to finally make a living off our own soil and have a kind of life that we're proud of and that our son can be proud of and take part in. We have a family business, and we're really proud of it. And this is just one tiny little phase of it that I don't care to continue, but since the opportunity did arise, we thought that since we're such long-standing members and serving members of the community, that we should have a chance to do something with this opportunity. Thank you.
Thank you. I have a question of the appellant. Is this your first attempt at cultivating marijuana, sir?
No, I have a history going way back.
Okay. You don't need to go elaborate.
Yeah,
I just want
thanks.
to make sure this is one of your first
I've
endeavor.
got an awful lot of experience.
Anything else to add, sir?
Well, I'd like to say I'm really glad that another term that was used earlier this evening was come out of the closet. I've always felt like cannabis is a safe and effective product, and society is gradually coming around to accepting it. And I've always felt like we shouldn't have to hide. We who grow a good product without harmful chemicals, without harming the land. And as I've stated earlier, this is a certified organic operation. They don't allow a lot of practices which I am very much opposed to in our community in cultivation of marijuana. It's a plant and it's a product that does not have to be grown in an invasive manner at all. And I'm very proud of the operation we have. I felt when I first read the proposal and what was required for legal cannabis production that the ordinance was written for me and my family and our operation as we run it. The fences were all built, the land is all prepared, irrigation systems were all in, and the practices that we use, as I said, are all in accordance with the NOP, which is the National Organic Program, written by the USDA. It's very strict. We find that it is no problem for us to stay within those guidelines. We are inspected annually through CCOF by a representative of USDA. USDA does not wish to have me claim that my cannabis is certified organic. The way they feel is that, and you know, I can't quote word for word if you wanted documentation, but they, as long as it is against federal law, they just don't want to get involved in it. But if I'm growing it on my organic farm, I have to do it in accordance with anything else I do on my farm. We also raise certified organic chickens, certified organic beef, and the inspections are quite rigorous. My bookkeeping must be quite accurate, and they basically just ignore the cannabis when they see it. And like I said, everything that I use, which is minimal products we use, we really believe in using natural soil. We use cover crops. We use nitrogen fixing legumes as a cover crop, which is disced in every year, and as in this field here, it is allowed to sit for a few years if it can, and the nutrients increase, the organic matter increases, so you move your agricultural operation back onto there, and we don't need to use harmful chemicals of any kind. Our plants are so healthy, we don't need pesticides. If we do need anything, we only use products which are approved by the NOP, and it's all documented. I could elaborate on our operation, our history. I lived in Mountain Ranch. My parents and I bought not exactly this land, but the body of the ranch. These are parcels that my wife and I have purchased over the last decade and a half, which adjoined the old ranch, but it was a turkey farm originally, and my stepfather and mother and I renovated it, and that's how we paid for it. I have a long history here going back to 1966, and I'm a very proud member of this community, and I have mixed feelings about the way a lot of the industry is here in Calaveras County. I think a better regulation, I think more thought should have been gone into it. Like I said, I don't believe that cannabis, I have proven that cannabis can be grown with a very low impact to the environment, and I hope that the board can see what my wife and I are doing, and that we're a very positive operation, and that we can proceed legally. If I could, I'd like to make my operation available for any further consideration of regulations that may be considered. If you'd like to study a farm that is an extremely low impact cannabis operation, I would be more than willing to invite you to my farm and show you around. We're very proud of our operation.
Okay. Sir, are you aware that the board can only consider information presented at the hearing for the Planning Commission? We can consider only that information presented at that board.
Okay?
Okay? And the information you just provided, was that information provided at the board hearing?
Part of it, I believe, was.
The information you just related,
Yeah.
was that information presented at the Planning Commission hearing?
I believe that it was.
Believe
It wasn't
Okay.
exactly the same, but that, it was, those issues were discussed.
Yeah,
Okay.
I'm very passionate of what we do, and once you give me an opportunity,
no,
I can't stop.
Sir, I'm not going to stop you from speaking. I just want to make sure we're talking
Yeah,
apples and
if
apples
I
here.
see interest in faces, I keep
No
going.
pun intended.
Yeah,
Okay, thank you.
yeah.
Anything further? This time we'll open up public comment, maximum of 5 minutes. Are there any public comment speakers? Seeing none, we'll bring it back to summation and rebuttal by appellants. Do you have anything further to say, sir?
yeah, you know, there may be things I think of later, but, yeah, we're just we're a very low-impact operation, and I'm very proud of what we're doing, and, yeah, I hope we get the opportunity to go over these issues and clarify this with the presence of our attorney. She has a very meticulous case prepared, and unfortunately, she's not here tonight.
Thank you, sir. Staff rebuttal? Summation and rebuttal.
I have nothing further to add, unless you have any questions of me.
Counsel?
I would just like the record to reflect, considering the statement indicated a violation of due process because my office represents the planning department as well as the board. My office is very cognizant of prosecutorial versus advisory roles within the office. I would like the record to reflect that there is, in fact, a separate attorney that has been advising and representing the planning department as it relates to this file. I have not in any way, shape, or form been in communication with this attorney as it relates to this file or this appeal. And my role for this hearing is advisory to the Board of Supervisors. So I just want the record to reflect that.
Okay. Thank you, counsel. Further staff summation? Any surreal rebuttal by staff members of the public? Seeing none? Is there any board questions of any staff, appellant, or presenters? Seeing none, we'll close the hearing.
I'm here.
I'm sorry. I missed your light.
Sorry, yeah, it's getting late.
It's been a long night.
We'll have to wave the wand again. In the appellant's statement number 6 by their attorney is to consider the remand to the Planning Commission to consider further information that was not available at the time of the application processing. Is there any new information that the Planning Commission received that would substantially change the outcome of this hearing today? Would be a question. What new information would there be?
I don't believe there is any new information. There may have been additional information that the attorney wanted to submit, but because she's not here, it was not submitted. So there is no new information that I'm aware of. Anything that we discussed today was in general discussed at the Planning Commission. So there's no new information.
Thank you.
Any further questions by the board? Seeing none, I'll close the hearing. We'll have board discussion deliberation. Anybody want to chime up first? Supervisor Mills.
Oh, I'll go. The applicant made the statement this field fallow for a few years. You know, I got to refer back to the Google aerial there of May 31st of 2016. I didn't ask staff to bring that up. Thank you. But, you know, it says very clearly in the urgency ordinance that there must be evidence of cultivation, grading, something. I don't see, this is well after that deadline, and yet there's no evidence on that parcel to indicate that there was any activity on or before May 10th. So photographs or not, even though photographs are required to be submitted, the aerial imagery still is the final evidence in terms of whether or not something was actually occurring on that parcel. So I don't have any way to support the appellant here as to whether or not that activity was commenced prior to May 10th and to what level it was commenced. So I have no option here. We don't have enough information to overturn the Planning Commission.
Thank you. Any further comments by board members? Seeing none, I entertain a motion.
I do have a comment. I won't be supporting this appeal. I will be supporting the Planning Commission's denial of this appeal simply because there is no evidence, it doesn't show any evidence that there was any cultivation on this lot at the time it was, or prior to May 10th of 2016. It's very obvious there's nothing, it's not anything on there being cultivated. And as Mr. Maurer pointed out, if it was under trees, then it should have stayed under trees, and the photographs should have given us showing that. Instead, the photographs are showing that it's out in the open, but yet the evidence from the Google Maps show that nothing is transpiring there. So I can't support.
Supervisor Garamendi, any comments?
I'm afraid I agree with Supervisor Tofinelli.
Supervisor Clapp? I concur with Supervisor Tofinelli, Supervisor Garamendi, and Supervisor Mills. I think this lacks the evidence to uphold any appeal. I would not support overturning the decision of the Planning Commission. Having said that, I would entertain a motion.
I would move to uphold the Planning Commission's denial of this appeal.
It's been moved by Supervisor Garamendi. I'm sorry, Supervisor Tofinelli. It's been a long night. Second?
I'll second the motion.
Seconded by Supervisor Garamendi. No more further public comment. All in favor indicate by saying aye. Aye. Opposed indicate by saying no. Hearing none, motion carries 5-0, unanimous.
Item 29 is from the Planning Department to conduct a public hearing and adopt a resolution upholding the Planning Commission's denial of the appeal of the Planning Director's denial of commercial cannabis registration 2016-655 for Norman Gunsel and Amy Volpe Gunsel at a site located approximately 700 feet west of Adobe Gulch Road at a point approximately 1/2 mile north of the intersection of Cave City Road and Adobe Gulch Road, Mountain Ranch, APN 036-031-016.
Okay, before we open the hearing, I want to make sure that everybody's aware that the statement read into the record on the previous item by Mr. Gunsel does apply to this particular agenda item also. We'll open the hearing. Mr. Maurer, proceed,
Yes,
please.
this is the second of the appeals filed by Mr. Gunsel, and just for the record as well, the request for continuance applied to this application as well, which you unanimously decided to continue on with the hearing or to hold the hearing and not continue the item as requested.
Mr. Maurer, could I interrupt you for a moment? Council, do we need to take a poll or vote on that, on each individual item? Or?
The board can certainly take it all at the same time since it's the same applicant, the same council, the same issue. However, for the record, I think that it would be wise to refer back to the discussion and the vote on the prior item so that the record is clear as far as the basis for the denial on the prior appeal is continuing forward for this appeal and then the next appeal in front of the board.
Thank you, Council. So be it understood that the request for continuance and the results of the item number 28 does pertain to this particular item and the following item, which will make that announcement for the record at that time. Proceed, Mr. Maurer. Thank you.
All right, thank you. This is appeal of cannabis cultivation registration 2016-655, denied by the Planning Department and appealed to the Planning Commission. This is appeal of the Planning Commission's decision to deny that appeal. The reasons for denial by the Planning Commission were that the cultivation area was not set back to require 75 feet from the property line. The cultivation area was not secured by a lock. and the certificate of registration was not properly posted at the cultivation site. This is the location. It is immediately to the west of the prior site that we looked at in the previous appeal, again at the end of Adobe Gulch Road. This shows that in relationship to the other applications, you can see the identified parcel in red. You can see the area of cultivation. This was taken in June of 2016, prepared for cultivation, but no actual plants in the ground at the time. And you can see that it straddles, the whole large cultivation area straddles both two parcels. This was the site plan submitted for both, and they clearly understood that a 75-foot setback was required from on both parcels from the property line. That was a requirement of the code, and they understood that by showing that on their application site plan. Shows a 75-foot setback from the common property line, which is the dashed red line there. This is the photograph taken at the end of the season last year. Shows cultivation straddling the property. And this was the primary finding was that the setbacks failed to meet the cultivation failed to meet the setback requirement of 165 and 8. Furthermore, an inspection was done in July of 2016. The code compliance officer identified that the cultivation area was straddling the property line, and they had made a single grow out of what was supposed to be two separate cultivation areas. The code is very clear that you can have up to 22,000 square feet per parcel of registered, but they need to be separate, and they had to maintain the setback from property lines regardless of ownership. In this case, there's 4 parcels that are adjacent, common ownership, but the code does not differentiate, and we've been very consistent in applying that and telling people that, no, you need to meet the setback even if you own 2 parcels. You could combine them into a single parcel, but then they were restricted to just 22,000 square feet for the one combined parcel. Also notice that the posting showed the posting of both cultivation areas on a single site rather than separately as required to be done for the 2 separate cultivation areas. Code compliance went back in January to follow up, and the setback violation continued to be observed. At that point, a notice to comply was issued. Appellant was informed that the 75-foot setback had to be maintained from the property line, and they were instructed to contact planning to discuss alternatives. The appellant did not contact the planning department, and so the result was the denial of the cultivation area based on that provision. In addition, code compliance identified there was no lock or gate for the fenced area, and so it was unsecured and in violation of section 165 and 10. This was in July of 2016. Again, in January, there was a chain up there, but it was not locked, and so it still failed to meet that requirement. They were provided an opportunity to correct that, and after several weeks, no correction was provided, and so that was also included as a reason for denial of the registration application. And the third item was the inspection notice that they weren't properly posted. These are just some laminated sheets. They're supposed to be attached to a wooden board, at least 18 square inches with reflective material. So this was not, did not meet the standards of the code. Again, this was first noticed in 2016. The applicant was notified of that discrepancy with the code. A follow-up inspection in January showed that there was no posting, and again was provided notice to correct, which did not happen. In the letter of appeal, the appellant stated that he was awaiting response from code regarding the setbacks and under common ownership, that the locks were not in place because at the time there was no cultivation occurring. The posting had been damaged due to storms, and new ones would be posted, and that the failure to respond timely was because the internet was down and he did not receive the information from code compliance that he needed to comply within the time frame specified. During the hearing, we discussed the setbacks, identified that there was common ownership of both parcels, that and Mr. Gunsel, said there was advantages of having one large grow rather than two large grows, and there was some informal discussion at the inspection on January 17th. Again, code responded to Mr. Gunsel in writing on the 19th and provided him a clear description of what needed to be done to correct the violations. The appellant did submit a picture that was dated, or we received it in July, that showed the dual posting of the site, but this was clearly taken much later than the deadline that was provided to the appellant. Again, discussed the failure of the internet, and there's some question about the date of when they were required to comply with that. The same issue sort of applied to the locks. Again, there was no locks shown in the photographs. There was never any attempt to, or no documentation of an attempt to comply, of simply putting a lock on the chain around the gate. And so they did not submit the proof of compliance within the time frame specified. The commission found with regard to the setback area that the plot plan showed that the registrant clearly understood the setback requirement. He was told to comply in July, was given written notice to comply in January, but did not do so. With regard to the posting, again, was told several times and provided written direction to post it properly, and the commission found that he did not do that and did not do it in a timely manner. With that, the planning commission the commission denied the appeal, and we recommend that the board uphold that appeal.
I'd like to point out that the code enforcement officer who conducted those inspections is present here, and he'd like to go home. So if you guys wouldn't mind, I'd like him to come to the podium and present any authentication that might be necessary and allow you guys to ask him any questions that you'd like to ask, if that pleases the chair.
It's part of staff presentation, so I would allow it.
Thank you. Tom, would you come up? Tom was supposed to get off at 4:30. He starts at 7.
Tom Watts representing Code Compliance. If you've got any questions, I can try and answer them.
Tom, when you went to the site, did you observe that that the grow site straddled 2 property lines?
Yes.
And did you observe that the grow site did not have 75 setback from the property line?
Yeah.
Did you find that there was proper posting requirements met?
Yeah, there was no posting there. I should point out I only did the inspection in January. One of my colleagues did the one
Sir,
in
I'm going to
July.
ask you to speak up and right into the microphone.
I only did the inspection in January. One of my colleagues did the previous inspection.
Okay. Did you find the security requirements of the code were satisfied?
No, there was no lock.
Was there a gate?
Yes, there were gates, just no locks.
Okay. And I also would like to address the statement made in item number Three, that that it violates equal protection by treating code violations as a basis for denial, when the code expressly authorizes the planning director to deny or invalidate applications for code violations. And I just have one more question for Tom. Tom, did you provide notice to Mr. Gunsel of the violations he observed on the property?
Yes, I sent him several emails.
And did you provide him with a reasonable time to correct those?
Yeah, I believe it was 10 days.
Did you ever receive any indication that those items had been corrected?
No. We emailed back and forth a little bit, but ultimately I never received any proof of any of the corrections. So by him returning emails, it sounds like he had received your notice.
Yes, certainly.
All right. I have no further questions for Tom. If you guys do, please feel free.
Board have questions of our compliance officer?
Go on.
Supervisor Garamendi?
Tom, when was the last time you were out at the site?
I haven't been back there since the inspection in January.
Okay, thank you.
Sir, we're talking about 3 permits in 3 individual sites, correct?
Mm-hmm. Yeah, that's correct.
All right. Identified in your documentation by APN number and also by permit number, correct?
Yes.
Okay. Thank you. Further questions of our code compliance officer?
Actually, there was 4, is that not correct?
I believe there are 4 applications. I only did the inspection for 3 of them, though.
You inspected just 3 of them, the
Yeah.
4th one was not, okay.
Okay. Thank you. Counsel,
Tom, if you could hang around in case Mr. Gunsel has any questions for you.
Yeah, no worries.
Then you can leave.
okay. Does that complete your initial presentation?
Yes, it does.
Okay. On this issue, Mr. Gunzel, you can speak as the appellant, and you can too, Mrs. Gunzel. Just a different site location, permit number. Is there anything you'd like us to know?
As far as the last, apparently I was sent an email telling me that I had certain things that had to be done by a certain date. This was in early February. From sometime in mid-January clear through February, our internet was completely down. The rain was incredible and nobody had internet at the time. I didn't think to go someplace or see if, is the board contact me. I have had letters from planning department before. I was under the impression that a reasonable attempt would be made to contact me if there was something serious. Like I said, our internet was down. Of course, we went and got the mail all the time. Nothing came in the mail telling me I had any kind of a deadline. I didn't find out about this until finally our internet came back sometime like at the end of February, and I found this email and it was like, holy smokes, what do we do now? So I ran down to the planning department right away and it was like, too late, you guys. We gave you this time and the clock ran out.
And no phone call.
Yeah, phone worked fine.
We don't feel that there was
A reasonable attempt to contact us on these matters. As far as the block goes, there was a couple of photos there where there was the chain was laying on the ground. If you want to run the photo back, and the block was laying there too. Of course, the gate wasn't locked because we were in the garden at the time. We don't lock the gate behind us. At the time of the inspection, we were in the garden. Yeah. And you can see the lock. I believe that's the lock laying there, but I can't swear to it. We keep the gate locked in the evening, of course. The gate is always locked at both entrances to our operation.
And at our driveway.
Yeah, our driveway is the main driveway is the one Yeah, what are some of these other ones? Oh, as far as the setback goes, I talked to one of the officers at length about the 75-foot setback in January. He informed me at the time that it was more for when an aerial inspection is taking place, they want to be able to see where the property line is. And since we own both parcels, the property line straddles the garden itself. This is an established garden. We built this fence probably 15, 18 years ago. I built a round fence because it's a deer crossing. There's a deer habitat on both sides of us, and I didn't want a square garden, so I wanted a round garden so the deer could get around it easily when they ran from one place to another. I didn't want to disturb that. I didn't want to disturb any more new ground. He was quite receptive of that and
Basically told us not to worry about
told
it
us
this
that
year.
he would get back in touch with us. And I said, well, what about like a 30 or 40 foot swath so the plane can easily see? It's a straight line, goes right through the middle of the garden. He was going to get back in touch with me. I know it's my responsibility. I'm not trying to lay the blame on him, but that was the impression that I got, was that it was more of an issue about allowing aerial surveillance to see exactly where the line was, which is what we did.
Any further?
What are some of these other issues?
If not, I have a question.
Okay.
Sir, did you submit your application fee monies
Oh, yeah.
at the time you submitted?
Oh, yeah.
And how many applications did you submit?
4.
So we're talking $20,000?
Something like that, yes.
Okay. And then you also had your initial investment?
That's right.
And materials, labor,
Put
things of that sort?
everything into it that we've got.
So you could have close to $100,000 invested?
I'd rather you not remind me.
And what was the size of your permits? 22,000 square feet on each?
Yes, on each one. On each one.
Thank you. Supervisor Garamendi?
I'm sorry, Gary. Mr. Gunsel, if I flew over your property today, would there be 150 feet between your two crops?
No, there would not.
You clearly were aware of that from your
Yes,
site plans.
Yes.
Thank you.
Further questions? Supervisor Clark?
I have a question for code enforcement. Did you leave a written notice on the property?
No, just emails.
Just a verbal?
No, we emailed back and forth. So Mr. Gunsel saying that he never received the emails isn't entirely true. He certainly received my first email.
Okay, my question was, so you never left a written notice on the property?
No, just emails.
Thank you. This is the county council. Considering this is to do with real property, does an email count as written?
This is a matter of identifying or being able to provide the property owner notification of the potential violations and an opportunity to correct. So I'm not quite sure what the question is.
Anything pertaining with real property has to be in writing. It can't be verbal. I know I'm a builder, and every time I have a code violation or anything, I'm always notified in writing. It's not a verbal, it's a written
Email
complaint.
is considered a written form of communication.
So the, Mr. Watt's email was sent on January 19th. Mr. Gunsel responded to that email on January 21st and in that initial email, it listed all of the violations that were identified, including some that he did correct, but it included the locks, included the setback, and the posting. He indicated that Some of these issues can be done right away, but the rest will need more than the next 10 days. So he's clearly understood the 10 days. Mr. Watts then responded on January 23rd, asking which corrections will need more time. Mr. Gunsel responded again on the 31st.
Peter, I was just wanting to clarify if
So I
the
just wanted to
emails
clarify
was the
that there
same
was
as that.
clearly
So
communication. He was aware of it. The statement that he did not have internet connection from the middle of January through February just is contradicted by the evidence in the file.
Can you go back to the plot map that was filed with the application? And that's the plot maps that were submitted by the applicant for these two properties.
That's correct.
You know, this is tantamount to me to me submitting to the building plans to build something on my property, a house, and showing its location like you need to do, and then end up not building a house, building a barn over to the right-hand side of it across somebody else or a piece of property that I own too. You knew when you submitted this, that's what you submitted, that's what you decided you wanted to do, that's what you submitted to do. You can't change that. You can't decide, well, I'm just going to go across because of deers and so forth. To me, this is what you submitted. This is what needs to be on there when inspection comes out to inspect your property, because that's what you submitted. And that goes through any trade, whether it's a building trades or any other thing. You submit that to get your permit, and you can't get a permit if you've deviated from that. You have to go back and resubmit plans and go forward. So I just don't understand how you ended up with what you got, what you planted versus what you submitted. It's not. That was your application. So I don't know why you decided to do that. If you have an explanation for it other than the deer situation that you talked about. But obviously you knew you had to submit the 75-foot setbacks, and you drew these maps, these plot plans. So that's what you submitted.
The fence was established, like I said, almost 20 years ago, and yeah, I was under the impression by the inspector that came that since I own both parcels, that this could be worked out with county. I know the buck stops with me. I should have gotten back, but nobody got back to me about this. And as far as the emails go, okay, I can't tell you exactly when we lost our email contact or our internet, but I was responding to Planning Commission. I remember emailing them back saying, yes, I just need some more time. These are some things that I got done. I can't be specific with the date, but the one that I got early in February, I was not able to find it until like late February, March, when our internet finally did come back. If I had received that, if I had received a letter or a phone call, I certainly would have contacted Planning Department and let them know that I please need a little bit more time, or yeah, a deadline was given. I mean, I could have scrambled and got these few issues done, but I didn't receive the email. The internet was down. If anybody remembers, the weather was quite atrocious at that time.
Thank you, sir.
I'd like to show Mr. Gunsel his emails so that he sees that he responded.
Yes, I remember
Gentlemen,
those.
Gentlemen, I think we can proceed on with our hearing here. Is there anything further, sir?
No.
All right. This time, public comment, please. You're limited to 5 minutes. Any public comment? Seeing none, we'll go back to summation and rebuttal by the appellant. Is there anything else you'd like to present, sir?
Well, again, without having my attorney here, I'm sure there's going to be something that crosses my mind, or she's going to say, well, why didn't you bring this up or that? I mean, it's getting late. I mean, let's just carry on with this,
Okay. Staff summation rebuttal?
The only issue I'd like to bring up was a statement that Mr. Gunzel just made, was that, we didn't contact him. Well, he didn't contact us. He was told to contact us. We never received any communication from him regarding the setback. So there would have been no reason for us to contact him because we didn't know it was an issue that he was waiting to hear some response on.
So rebuttal by members of the public?
I have a simple question. This was one of the grows that got inspected, correct? Who provided escort? CHP or the Sheriff's Department? Was anybody there? Did he come out with an AK-47? Did he shoot anybody when he came on the property? No. He owns both pieces of property. I grant he goofed up somewhere along the way. I don't know why. He's got 2 plot plans. He's supposed to have 75-foot setbacks, and the photographs show it overgrows. He's going across 2 pieces of property that he owns. There's a fence between them. He should have gotten with planning. If this was your house, your property, you would have worked with planning, correct? You would have went in and you would have said, look, it's just not going to work the way I planned it. I know I submitted this, but we're going to have to make a change here. And it's going to have to go across. Can I put these 2 lots together and we're just going to make it one grow? He didn't do that. He didn't do that. You're going to reject him anyway and deny it. So what the heck?
Thank you.
Bill McManus. I really don't see how you guys have much of a choice. Now that the urgency ordinance has been extended and we're 7 or 8 months away from that extension date, you guys own the urgency ordinance. You can't blame past boards anymore. This problem could have been fixed back in March, and it wasn't. But it's your ordinance. And when people violate your ordinance, you either decide to ignore your ordinance or you enforce it. And all of the other stories and things surrounding it don't really make too much difference. If they violate the provisions of the urgency ordinance, it's up to you to uphold the urgency ordinance. And I don't know why we have so much drama surrounding this stuff. It's it's pretty cut and dried. 20 years as a contractor, I knew that if I didn't do something right, I was going to get nailed and had to fix it. And I didn't get my permit until I got everything right. So this is your ordinance. I hope you live with it for as long as it lasts and do the job that you're elected to do, and that's to enforce the ordinances that you impose on the county. That's your job. It's not to try to find a way around it or say, well, really it's not that big a deal. It's a big deal. You considered it, you passed it, and you're living with it. It's yours. So I hope that you guys just do the job that you're supposed to be doing and enforce your ordinance. Thank you.
Further public comment or rebuttal by the public? Seeing none, we'll bring it back to the board for board questions of the appellant, staff. Any questions? I'm sorry, counsel, wish to speak?
Yes, Board Chair, thank you. Similar to the prior hearing, I just want the record to reflect, considering the item that was entered into the record regarding my office representing prosecutorial and advisory sides. I just want the record to reflect that we are aware of the different roles that the council, the separate council that is assigned to the planning department, is separate from myself. We have not been in communication with this case or any of the cases in front of the board today. My role is to advise the board, and so it's purely advisory. I am not sitting in a prosecutorial role as it relates to this case.
Thank you, counsel. Further questions by the board? Hearing none, we'll close the hearing. We'll have board discussion, deliberation. We'll start with Supervisor Clapp. Your light's on. Would you care to speak?
I have nothing to say.
Okay. Supervisor Mills.
I think that the planning department has put together a fairly good case in terms of whether or not they have complied with 165N10 and 165I and the other pieces. I don't see any compelling evidence to overturn any portion of the material that you have presented to us. So we're there.
Supervisor Tofinelli?
Yeah, as I stated earlier, I can't understand why you would submit this and not do what you plan to get your permit. So it obviously fails the setbacks that were needed to get the permit. So I will be supporting the Planning Commission's denial.
Supervisor Garamendi?
Mr. Council, I agree with Supervisor Tofinelli. You knew the rules, and it wasn't the 1 year you did it wrong. You did it the second year, this year as well. And I mean, I'll be supporting the Planning Commission also.
I have a concern. When someone invests $80,000 to $100,000 and they're faced with the lines of communication being inoperable for a period to extend to this did, I would have great concern. In fact, I would have so much concern, I'd try to get a hold of somebody. Although that's just me. I'm not saying that every standard has to meet that criteria. Having said that, I would concur with my fellow supervisors. I think the issue does support the Planning Commission's decision, and I would support the Planning Commission. Having said that, I'd entertain a motion.
So moved.
Moved by Supervisor Garamendi. Second?
Second.
Second by Supervisor Tofinelli. No more further public discussion. All in favor indicate by saying aye.
Aye.
Opposed indicate by saying no. Hearing none, motion carries 5-0, unanimous. Madam Clerk.
Item 30 is from the Planning Department. To conduct a public hearing and adopt a resolution upholding the Planning Commission's denial of the appeal of the Planning Director's denial of commercial cannabis registration 2016-656 for Norman Gunsel and Amy Volp Gunsel at a site located at 8380 Garibaldi Street, Mountain Ranch, APN 036-001-051.
Okay. Before we start the hearing, I want to make public notice and on the record the email presented by the appellant on item number 28 does carry the same force and information as it does to the two prior issues as far as the content and information. At this time, we'll open the hearing. Mr. Maurer, proceed, please.
Would you also like to clarify for the record the action on the request for continuance on this item as well?
Okay, I would concur. The motion for continuance that was denied on item number 28 will hold the same statute in this particular agenda item, and that was a denial of the continuance. Is that correct?
Yes.
Counsel? Is that correct?
If that is this board's ruling as it relates to this request for continuance, then yes, this board can move the basis for the denial of the continuance forward to apply in this hearing as well.
Okay. And for the record, do I hear any opposition to that from the Board of Supervisors? Okay, then it will stand as stated. Proceed, Mr. Maurer.
Okay, this is the appeal of 2016-656, again by the Gunsel's. This was the appeal of the Planning Commission's denial of the appeal of the Planning Department's action to deny this. The reason for denial was that not secured by locks, fencing was incomplete at one cultivation area, leaving it unsecured. The certificate of registration was not posted at the cultivation site, and that the application for registration contained false or misleading information. This is adjacent to the other two that we just looked at. This is to the north. The access comes off of Garibaldi Street from Mountain Ranch. And there is the aerial imaging showing the parcel in relationship to the other applications to be filed. This was the site plan that was submitted with the application. It shows 3 separate garden areas, as well as the residence on the property, the driveway coming in off of Garibaldi Street. With the inspections that were done in July, code compliance identified that there were no locks on the gates and advised the registrant to make sure they were locked. Again, the inspection done in January showed still no locks on the gate, just a clip. Provided 10 days to comply starting on January 20th, and no proof of correction was submitted by that deadline, so it failed to meet the requirements of 165 and 10 of the urgency ordinance. The inspection of July showed an unfenced or an incompletely fenced area next to a trailer. Again, they were advised to provide fencing. Went back out in January, and although there were dead plants in the cultivation area, yes, Mr. Watts is here to confirm at the Planning Commission hearing that those appeared to be the remnant stalks of cannabis plants. I too have been out in the field many times, and that's what I would recognize as being cannabis plants that have been harvested. Again, provided 10 days to comply, and no proof of correction was provided to the county to meet that requirement. The posting, the registration for that site was not posted. It was advised to post back in July. When they went back in January, still had not been posted. Again, the 10-day compliance time frame was provided, and it did not. They did not comply within the 10 days as provided, which was a violation of 165I. Finally, the failure or the false and misleading. If you look at these pictures closely, you can see these really are the same picture, or pictures of the same plants taken on the same day, yet the dates on each one are different. And it's clearly just simply couldn't be. There was a 2015, October 3rd, 2015, a September 2014, and October of 2013. But if you look closely, you can see that these are just various views of the same garden at the same time. They could not have been so identical 3 years apart. So we felt that this was false and misleading information that did not accurately show the time that, the times that these photographs were actually taken, and that for whatever reason, these dates were manipulated to provide an indication that he'd been growing these plants since at least 2013. In his appeal letter, he stated that there were no locks at the January inspection because no cultivation was occurring. There were no plants there to secure, and that the small cultivation area near the trailer will be abandoned. Again, the posting, the laminated sheet that required to be posted was damaged in the rain, and that they would install new posting, and they did not address the photographs in their appeal letter. During the hearing, These photographs were submitted to the Planning Commission. However, well, it did show that locks and chains were on the gate, but there's no reflective material on the signboards, and unfortunately, these were not submitted within the 10 days as required. These were clearly taken in summer. If you can look closely at the pictures, you can see that this is dry grass, thistles in later in the season, not the springtime. So these were taken clearly well after the 10-day compliance timeframe provided. The appellant indicated that the cultivation area was abandoned without harvesting, that the stalks, however, the commission determined that the stalks appeared to be cannabis. There was no proof of abandonment, nor was it submitted within the 10-day. The council had requested that this violation be dismissed as a part of the code violations. However, the Planning Commission did not take that action.
Excuse me, Mr. Mauer.
Yes.
Going back to that last slide, council requests dismissal of code-based violations. Which council?
The appellant's counsel.
Okay, thank you.
The appellant's counsel indicated that these dates were generated from computer data, but there was no further explanation that was provided as how the computer could apply different dates to what essentially are the same, the photographs taken at the same time. So the findings of the commission was that the reasons for the original denial were valid, that they did not post the cultivation area as required within the time frame provided, that the locks were not properly installed, and no evidence was provided within 10 days, as well as the one cultivation area was not fully enclosed, even though by that time there were only the dead stalks within the cultivation area. And they felt that the photographs that were submitted were false and misleading. So we recommend that you uphold the Planning Commission's findings and deny this appeal. Do you have any questions?
Questions of Mr. Mauer? Supervisor Garamendi?
Mr. Mauer, are these visits announced in advance? People know you're coming when the inspector goes out?
I would defer that question or refer that question to Mr. Watts.
Mr. Watts, do you call in advance, let people know you're coming?
It depends. If time allows, we generally call in advance. Sometimes we turn up unannounced. I honestly can't remember whether we scheduled this one.
Thank you.
Okay. Further question, Mr. Mauer? Supervisor Mills?
He's trying to turn.
He beat you with a light.
Yeah, I know. So did you show up to work today? What time?
7 o'clock?
You had lunch today?
Yep.
Did you have dinner?
No.
Do you have a place posted in your room where you have all your regulations for your employment? Do you know where that's posted at?
I guess it's in the kind of kitchen area.
Yes, it's there.
So we have our employees work, no food, no work, no overtime? What's going on? We have several employees in here right now.
I understand, Supervisor Clapp.
My concerns are for them.
I understand, sir.
Can't discuss it, though.
You need to go see Human Resources tomorrow.
Mr. Mauer, my question would be, on the county aerial of August 20th, which was posted on the previous agenda, but not posted on this one, I found something rather interesting here, and that if you blow up that the lower right corner, you will find a whole different growth site in the trees. Or maybe I'm just seeing things. But if that's the case, where's the fencing on that? go down in the lower right corner of 653, where it turns, it makes that dog bone or kick. And that's the June 9th one.
653
We're
is
talking
not
about
before
we're talking about the August 20th aerial. August 20th. It's the later aerial.
So
There.
that was one that's in the packet, not in the,
Okay.
in the,
It's just rather curious that there's a complete grow that happened right in that area. But I'm on page 671 of our packet. So it's on the previous agenda. It wasn't included in this agenda item, but it applies generally to the discussion. I understand it's getting late, but then they come down this way, right here. Blow that up right in there. That's it?
Yeah, right here.
So were we growing additional plants in the trees out of view and we never noticed it, and so therefore here's another code compliance problem? That never got noticed? Just making a point.
I do not know the status of application number 653. It's not before us today. So I
But
have
it
to
does
do
cross boundary lines, and it's not in the 75-foot setback. You got a number of things going on with that, so,
research. Not in compliance with the application that was submitted. Yes, there are a number of things.
thank you.
Okay. Does that conclude staff presentation?
Yes, it does.
All right. Sir, you have the appellant presentation. You're up to speak now on this particular item.
Yeah, what exactly are we talking about right now?
I'm sorry, what was that?
What exactly are we, what issue are we talking about now?
This is item number 29, and it's, I'm sorry, item 30. Even I'm making mistakes, it's getting late.
Yeah.
Item 30 on site located at 8380 Garibaldi Street, the Mountain Ranch.
Yeah.
Okay. Do you have anything you'd like us to know
Well,
regarding this particular location?
well, the first thing that I would like to address is the dates on those photos. I'm not trying to mislead anybody at all. These were pictures. We knew we had to have pictures. I don't take pictures myself. I don't run around with a cell phone taking pictures. I had to get these from family and friends. They were curious too, because obviously it's the same picture there, but they have different dates on them. So we investigated that, and there is documented evidence that when you take a photo that's on a cell phone and put it on a computer, which is what we had to do, it can change dates. That's the only explanation I have. There's no reason why I would put these photos on there with different dates. You can see, yeah, it's obviously the same picture. I have a history that goes back of growing in this particular place for several years now. That's the only explanation I could have as to why there's obviously some of those dates are wrong, because you can't have an exact picture like that on a.
Is there anything else you'd like to add, sir?
The one area that I said I did abandon, I told them when they came out that we never even harvested that. I just let the rain wash it all away, and we were going to eliminate that garden. There it is right there next to the trailer. They said, well, you had to have a fence anyway, and it had to be posted. So it's posted now that I just increased the size of the fence, and there it is. I mean, there's nothing in there now, but we did comply with that. Now, yes, there were missing locks on the gate. Again, we were going in and out, in and out. This was in wintertime. The postings, I didn't have them properly laminated. The rains ruined a lot of these, and as I was cleaning up, I just said, well, we're going to have to get new ones of these anyway. So some of these areas, as was stated, was not posted. What was the other issue here? Oh, there.
No, that was on a different site. So the,
What else am I not?
It's on the first appeal that we
Yeah, that item has already been decided.
so
So-
the issues here are the locks, the posting, and the photographs.
Yeah, I can't explain how the wrong date got on those photos. And all these are locked now. They're all locked, they're all posted. We keep referring back to that I was notified. Again, I was receiving emails in January. I can't say the last date, though. It was the last email that I responded to, because when I would get an email from Planning Department, I would respond to it, and there is record of that. But then there was an email that I did not respond to. That was the one that I received when our internet was down, and it was a very important email that I certainly would have responded to. And like I said, by the time our internet came back on, the time had already passed. And I came right down and I asked if there was anything that could be done, and it was like, no, you're too late.
Thank you.
Sure.
Anything further?
Like I said, my attorney is going to say, well, why didn't you bring this up? Why didn't you bring that up? But she is not here, and so that's going to have to be at a later date.
I understand that. Now we'll have public comment, limited to 5 minutes. Seeing no public comment, we'll have a summation and rebuttal by the appellant. Do you have anything further to say, sir? No. Okay. Staff summation and rebuttal? Mr. Mauer?
Nothing additional to add.
Okay.
I'd like to once again point out that the email correspondence between code enforcement and Mr. Gunsel are in your packet. They clearly indicate that he received notice, that he responded, and that he was made aware of his deadline and responded to the email in which he received the 10-day notice. And once again point out in response to item number 3 on the list of complaints supplied by Mr. Gunsel's attorney, that the planning director is absolutely authorized under the ordinance to deny or invalidate a registration based on code violations.
Thank you, sir. Any board questions? Supervisor Garamendi.
Mr. Gunsel, were you notified by Mr. Ward in advance of his visit?
The one in January, yes.
And you still didn't put the lock on the gate, even knowing that the inspection was
There
coming?
was nothing in there to lock up. I thought, well, this is not going to be really an issue there. I mean, I could run to the store and buy a lock, but
I'm sorry, I have a hard time with this when you know they're coming. And go to the easy stuff.
there's a lot I was doing, boy. In the wintertime, I was a real busy guy.
I understand being busy.
Mrs. Gunsel,
Gunsel.
you need to talk. I know you need to talk. You can talk.
The day before the inspection, somebody drove over the lock that was on our gate. Oh,
All right, there you go.
sorry. The day before the inspection,
Somebody drove over the gate?
when they
Over the
unlocked
gate?
the gate and drove over the lock that was protecting the entry to our driveway. So, seeing this and knowing that there was nothing growing in the garden up on the hill, what parcel is that?
It's on 51.
On 51, one of these parcels, I went and I removed one of those locks, or I removed the lock from the garden up on the hill because there was no longer any crop to protect in that garden. I then took that lock to the gate that protected our driveway because that's where everything that needed to be protected was at that time. And that's why there was no lock on that gate when we were inspected the following day.
Ma'am,
I mean, you guys got, sorry,
go right ahead.
I was gonna say, I mean, you've got, what was it, 4 permits or 3 permits?
We got 4.
4, and we just spent the last, better part of 2.5 hours going over 3 of those.
Yes, I know.
And for that kind of investment, I mean, you gotta, I mean, that's not what we're discussing here.
I know I know that sounds like a really lame excuse, but it was the day before, and believe me, we were scrambling to do everything else that needed to be done that day. And I did what I thought was the best thing to do, which was to take one lock, which wasn't protecting anything, and put it on the place where that was protecting everything. That was my decision at the time.
I don't want to bag it up.
Okay, thank you. Further questions by the board of staff or appellants? Seeing none, I will close, I'm sorry. Sure. Mr. Watts, you can go home. I think we've heard all the testimony we need. Thank you for extending your time.
Be careful driving.
Board Chair. Just similar to the other 2 hearings, considering it is part of the record, I would like the record to reflect that my office is fully aware of the Nightlife Partners case. We are cognizant of the difference between prosecutorial and advisory functions. We have separated out a separate and distinct counsel for the planning department and code, and a separate counsel for advisory to both the planning commission and this board, as sitting as the decision-making body for these cases. And we have not discussed this case or any of the other cases between the attorney who sits in the prosecutorial function and myself as the advisor to this board.
Okay, so noted. At this time, I'll close the meeting on the hearing. Bring it back to board discussion deliberation. Anybody want to go first? Supervisor Mills.
I think the appellant has admitted in this particular situation to all of the things which code compliance had found, and all of them are requirements under 17.95. It's not an option and was never intended to be an option, and not doing these basic things put a lot of things at risk, and it's a sad situation to go through that, but you know, the laws, the rules that were put in place was for everybody to follow exactly what was there. There was no options. So I won't be supporting an overturning of this. I will be supporting the Planning Commission.
Supervisor Clapp, any comments? Supervisor Tofinelli?
Yeah, I support what Supervisor Mills said. Geez, to me, with the amount of money invested, you would think that, well, I go get into what Supervisor Garamendi was talking about, but again, the rules are there. They have to be followed by everybody, and I will be supporting the Planning Commission's denial.
Okay. Supervisor
I've said
Garamendi?
enough, but I'll be supporting the planning commission's tonight.
I find that there exists sufficient evidence to support the Planning Commission's decision. I'm particularly concerned with the photograph issues and some other issues, and once again, those issues with an investment not being able to maintain some communications. So I would be supporting the Planning Commission's decision. Having said that, is there a motion?
So moved.
Moved by Supervisor Mills,
Second.
second by Supervisor Garamendi. No further public comment. All in favor indicate by saying aye. Aye. Opposed indicate by saying no. Hearing none, motion carries 5-0, unanimous. Madam Clerk?
Item 31 is from the Administrative Office to authorize the Auditor Controller to make short-term loans from general fund monies to meet certain fiscal year 2016-2017 operating expenses, which short-term loans shall be repaid when the related grant reimbursements are received. Authorize the Auditor Controller to transfer funds from the general fund to cover obligations for the outstanding operating expenses of certain departments for which no grant or other funds are available or expected to be received. Authorize certain technical adjustments with respect to the Rock Creek Gatehouse Capital Improvement Project. Authorize the implementation of the Cannabis Regulatory Program Memo. Requires a 4/5 vote of the board.
All right, that's my new budget strategy. Wear the board down and then have the closeout discussion. Unfortunately, this one did go last. I will try and be as brief, but provide the detail necessary as possible for this item. I just sent around, and we also have copies for the public, of an error that we noticed this weekend where 3 of the transfers were not, the backup documentation was not included with that item. It's important to note that the dollars did not change. You see the summary pages already. Those are just showing the actual transfer slips as backup documents to that. Actually, one of the staff realized that it wasn't on there on Sunday, and we quickly got that out and wanted to bring copies today to correct the record. But again, it does not change any of the requests that are outlined in the agenda item. So what this item is doing, and I know it's rather lengthy, is this is really our completing what we need to close out the financial books for 16-17. The auditor has been working through the accounts. There are a couple items that do require board approval, and that's really what's coming before you now. First of all, and it really takes about 4 main forms that you're seeing on there, and I'll try and succinctly explain what each of those are doing. First, we are asking for authorization for short-term loans from the general fund. And in a similar fashion to what we're doing, or what we did earlier with the transit program, this is asking for instances where programs did not receive their revenue timely, or in some cases, part of this is a cleanup from what I would say are long-standing practices that need to be rectified, and part of that is in order to be compliant with both Government Accounting Standards Board and also just generally accepted accounting principles for government. We really want to be recognizing revenue in the period that it's earned. In some instances, we were carrying revenue into the next fiscal year and really operating on a cash basis, which isn't a clean accounting process by any means. And so part of this is an adjustment cycle of trying to make sure that we're cleaning up the books and correcting that. The next step will be making sure that we're getting those timely invoices in so we minimize needing to do these loans. But it's not uncommon that governments do have some level of loan through their general fund, through their general accounts, while they're waiting for revenue to come in from state and federal sources. So in this case, we are asking for short-term loans for the Office of Emergency Services, for $142,454, and that's related to their needing the funds from their Homeland Security grant. Environmental Health for $34,000. That's anticipating waste tire grant funding that they have not received. The Anti-Drug Abuse Justice Assistance, not an easy statement, is also, we're waiting for $79,244, and then again waiting for those funds to come in as a due to from other government sources. Drug Enforcement Agency, Also, same type of a situation, 11,885. Those funds owed are due to an advance error, and we're trying to get those funds back. Marine safety for 43,921. Also due from other governments to us. That's for some of our contracts for marine safety that are out of the sheriff's office. A number of grants in the sheriff's office, 28,238, and then also 27,719 general accounts receivable, and also due from other governments for services, patrol services that have been provided. Victim witness also has a couple of items, 39,386, 3,931, and $344. And then XC victim witness for 8,879. Total amount that we're asking for in short-term loans, $420,001. If the board has questions on that piece, I'd be happy to answer that now, or I can keep going if the board would prefer. Okay, keep going. Next item is asking on, these are true shortages, transfer from general fund contingency to 3 specific departments. And as I indicated, those are true shortages. Either well, actually, I think in all 3 of these cases, we did not receive as much revenue as anticipated based on the expenditures. In the case of public defender, we typically have a portion of that gets billed, of the public defender contracted duties that gets billed to AB 109 based on the population that the public defender would be serving. The amount of billable activities or invoices was lower than anticipated, which resulted in less revenue from AB 109. The only other funding source available for that then is the public defender. In the case of the sheriff's office, which is the largest of the transfer from contingency, 99,113. I know that Captain Macedo is here to provide an overview of that. I can also provide a brief overview, and then the board, if they have additional questions, can ask. But this is in part due to when you look at some of the staffing shortages we have, and the sheriff having to make decisions on priorities for where to patrol. And as a result of that, if they can't offer services through some of their contracts that they have for contracted patrol services, then obviously that's not a billable activity. They're not billing out those contracted sources, and so it ends up falling back to the general fund. And I don't know, Captain, if you have more detail that you might want to offer on that piece, or a more thorough explanation if I covered it adequately.
In the interest of time, I think you did a fine job. I am here if there's questions that come up.
Okay, thank you, Captain.
And then also XC victim services, also again an instance where we had the required county match that was not budgeted in 16-17 that was missed when the budget was built, and so we needed to allocate that match to that program. So that would be a general fund regardless of the amount of revenue received.
Is it total? Sorry, Chair.
Go right ahead, Supervisor Garamendi.
Tim, what was the total contingency fund transfer?
The total contingency fund is $101,589.
How much was left in that account? I remember at mid-year, we were pretty much tapped that thing out.
At mid-year, we had about $400,000 remaining in there.
After we paid for, because we had some sheriff
We
makeup
did
stuff.
do that transfer, and we left about $400,000 in there.
Thank you.
And although certainly not ideal, I looked at contingency as the best source here because we were at closeout. It was already cash that was appropriated, but instead move it from one source to another. It doesn't decrease our fund balance, so to speak. within the current operating budget, but obviously it would have been available as fund balance rolling into next year had we not used it.
Right. Chair. Further questions of CAO West? Supervisor Mills.
I look at short-term loans as being exactly that, 90 days maximum. You will be able to report back to the board within 90 days that this entire loan package has been cleared.
Yes, anything from a standpoint of receivables, when we book those, both my office and the auditor will be working with those specific departments. In some cases, as Transit reported today, they're already receiving some of those funds. So you would expect at the longest, you might have some that are out 180 days, but those would be very unique, rare circumstances. Most of the time you're looking at receipt within 90 days.
Further questions of CAO West?
I was going to say I had some more items on here, unless the board had more questions on that. Sorry. The next area is technical adjustments that are not impacting the general fund. Those are instances where we did have shortfalls within a department's operating budget, but they also had a designated fund to draw from to offset that. In the case of the DUI vertical prosecution, we had a transfer of $33 to transfer an offset for a shortfall of an expired grant. And so that came from, that was from the district attorney's office and it came out of the DUI vertical prosecution fund. I want to clarify which designated fund it came out of to provide that. The building department was our largest item here. Now, when we were closing and providing these closing entries in the sake of conservatism, we aimed high in terms of how much we wanted to bring in from the designated fund. We indicated $225,000. Right now, it looks like it's probably about $125,000 is that shortage. And really the bulk of that is a result of some prior instances on general nuisance abatements, non-cannabis related, that that had been tagged improperly. Initially, the money had been pulled from Teeter, but then has to be repaid because they weren't. It was a procedural error that moved those funds over there, and it shouldn't have occurred in the first place. We have a number of cleanup items within the building department that we're working through that I think we'll see a number of these when we roll into the final year budget recommendation in a couple weeks that I'll be also bringing to the board's attention. This, I think, was just the beginning of us trying to unravel some of the structural problems with that budget. And then lastly, capital improvement projects for the Rock Creek Gatehouse. There was a instance on the Rock Creek Gatehouse where we had the project, but what happened is when staff originally budgeted that project at Rock Creek, they did not account for the rental of a temporary building and a porta potty, which then resulted in the shortfall of $24,000 that needed to be pulled out of the capital improvement projects public works designated fund. And then if the board had any questions on that item before I move to the last item, which is as we entered the first year, the full year, and needed to close out the cannabis urgency ordinance operations for last fiscal year, we needed to provide guidance to departments who are engaged in the regulatory or enforcement activities for cannabis within the county. So this item first includes an agenda item that is my memorandum to office staff that clarifies, and again, this was in consultation with council based on how the urgency ordinance fee was established. but it clarifies the allowable uses of the urgency ordinance fees. In order to properly document costs that are associated with the cannabis enforcement activities, including criminal investigations of additional crimes at the properties where there grows, supplemental law enforcement personnel assisting, and those types of costs, it was important that we identified a mechanism to capture those costs, recognize that they are part of dealing with cannabis within the county, although in this case, as an enforcement component outside of the urgency ordinance. So given that those costs are substantial, and in order to ensure that we are accurately capturing those, we did develop an additional budget unit to capture those costs. And so what the other piece that is in this item is some cleanup and closeout items that are recognizing costs, and in this case within the sheriff's unit or sheriff's department, where we're identifying regulatory unit costs, that's the responding with the sheriff's role within the urgency ordinance, but then also recognizing the enforcement unit costs, which really is the bulk of a lot of what we're looking at here. So for 2016-17, the sheriff's total costs relating to the cannabis program were recorded at $1,004,537. Of those, $223,333 are being allocated to and reimbursed through the urgency ordinance, which leaves the $681,204 that are being allocated to the enforcement program, and those would then fall under the general fund.
Tim, if I could just, what is we have $299,000 in change left in our contingency funds last year. Where's the source of that $681,000? Balancing the books with?
We're balancing the books with fund balance that is a result of, at this point, Measure C revenues that have come in.
So we're balancing the books with Measure C.
We're balancing the books with Measure C, and I'm waiting. Part of these entries will allow the auditor to close the books to get a true fund balance picture, to give us an idea of really our cash position, which then impacts our fund balance for next year. So it still reduces our fund balance that we would have had. So it's a cost borne by the general fund, because Measure C is an excise tax that is within the general fund.
Right.
So those are my points within this item, the areas that are covered in order to close the financial books.
Any questions of CAO Lutz? Any questions of Captain Macedo from the Sheriff's Department? Seeing none, we'll open it for public comment. Any public comment?
Quick question. I've heard that, at least it's a point of order, I have some comments I'd like to offer, but the question is whether I should offer them now or during public comment. And it does relate to Measure C funding and estimates of future revenue. Is that relevant to this agenda item? And if not, I'll hold my comments till public comment period.
Seeing that Measure C funds are included in the presentation and is used to balance the budget, I would allow that for public comment on this agenda item.
Okay, I will speak on this agenda item, but someone asked to let her go first, so I'll let her go first. That's okay?
3 minutes.
Good evening.
Hi, how are you?
Good, thank you. Vivian Zachu, District 1. Once again, in recent months, we have challenged the county financial management practices several times in our BOS meeting interventions. Today, the County Auditor Controller's Office is asking you, gentlemen, to take the responsibility of signing off on something that appears to be, once again, very little transparent and perhaps borderline non-compliant. Last time we checked, the general fund is a taxpayer-funded pot of money that is not supposed to cover deficiencies deriving from poor financial management practices such as cash flow forecasting and cost control shortfalls. Last time we checked, gentlemen, and please do kindly correct us if we are wrong, but commingling of funds is not allowed in public bodies accounting. Although the general fund can be used for loans, the concerning question is, can it be used for poor financial management practices to offset shortfalls? And loans, in any case, represent only a relatively small fraction of all the transfers under discussion today. In respect to all of the above, we would like to remind you that a state audit is fast approaching and could well extend beyond its intended scope of taxes assessment, gentlemen, which it is important to duly note that the majority of your general fund is derived from assessed taxes. Perhaps it would be wise to assume that maybe someone in Sacramento is listening and paying attention to what is happening in this chamber, gentlemen. Thank you for your time and consideration.
Thank you.
Okay, I got 3 minutes. I'm passing out a couple of spreadsheets which I put together to look at Measure C taxes. And basically the research question that I'm addressing with these spreadsheets is, what's the difference between the Measure C tax under the canopy tax and what is it going to be under track and trace? As you know, track and trace is a production, there'll be a production tax under Measure C. So to answer that question, I've obtained the numbers from the planning department and the tax collector as of July. And the first sheet, and now there's a lot here, but I'm going to just try to make this as simple as I can. There are 3 tables. The table on the left is a low estimate of taxes. Table on the middle is a high estimate of taxes. And then the third table is an average, or actually the median, because we only have 2 numbers. I took a number right down the middle. Now, this table shows only licensed growers on the first page. Okay? These are people that have finished the process and paid their Measure C taxes. And you can see in the field that's referenced G19, that's about 144 registered growers that have completed the process and paid their Measure C taxes. Now, if we take, now in the yellow that you see there, those are my estimates as to yield per square foot. These are informed estimates. I didn't make them up. I looked at research. I talked to numerous growers, and I know at least what our indoor operation can do. So I believe these estimates are in the realm of reality. Now, basically, what this chart is telling us, one thing, is that down the very bottom, we're looking at 42.24 acres licensed. These are the people that have finished the process. Then so we're looking at, if those people get licensed, those people pay their taxes under track and trace, we're looking at $27.9 million. I'm going to skip to the third page. The third page factors in those that have paid their Measure C taxes but have not yet completed the process. Assuming that all those people complete their process, there'll be about 261 of them. And my mid-range estimate, ladies and gentlemen, $50 million. Now, you can say I'm off. Say I'm off by 50%. Okay, 25 million or maybe 75 million. But we're looking, and it is my professional opinion, I look at spreadsheets all the time as a business person. I've been doing it for a long time. My educated judgment is that we're looking at around $50 million. It could be as much as 70 or more. We're looking at serious money. So what we need to do is we need an ordinance, and we need to get track and trace implemented by July of next year. And this is the kind of money you're looking at. Thank you.
Thank you.
Morning, or it's not morning yet. Wait a minute, I just took a nap. I'm sorry. Anyway, I have a problem. We have a sheriff's department that's billing the registration fees $250,000, correct? Close? Yeah, okay. What did we get for that money? Couldn't do the inspections. hasn't done the background checks. What did we get? Eradications of illegal grows. That's what Measure C was for. I have no problem, and I support law enforcement. But I do not support misspending registration fees for law enforcement when law enforcement was given personnel and did not perform their duty. I'm sorry. I wish they would. We've rejected everybody out here that didn't follow the rules. What kind of problem do we have with our own staff not following the rules? Not performing what they were set up to do, funded to do, given money to do, given equipment to do. When do we do something about that? Somewhere, somebody's got to account for that. I don't know who it is. We need good law enforcement. We need to get rid of the illegal grows. But we don't need somebody charging a fee to go out and do eradications and remote booking and buy 3D laser scanners. Thank you.
Thank you. Any other public comments? Seeing none, we'll bring it back to the board. Oh, hello.
Everybody went home.
I'll keep it quick. Trevor Whitkey, Calaveras Cannabis Alliance. The only thing I would request is if we could get a very clear accounting of the use of all Measure C funds as opposed to just having it coming out in meetings like this. It would be nice for us to actually know where every Measure C fund dollar is being spent, because as of right now, to figure this stuff out, I'm having to go through a lot of meetings and find very small, discrete conversations between the board, and it's not particularly easy tracking all of that down. So if we could get a report back on how these funds are being used, that would be awesome. Thank you.
Thank you. Any further public comment? Seeing none, we'll bring it back to the board. Any further discussion?
Mr. Chair, I think we're doing a good thing in trying to clean up the books at the end of the year and get everything settled out. I know there's a lot of debate about Proposition 26 and a lot of public debate about between the sheriff and the controller, and I believe that this remedies that situation. So I feel, and I'll be digging into these numbers closer, Prapana. If 76 acres produces $50 million in revenue to the county, we'll have to dig deeper into this.
Further discussion? Seeing none, I'd entertain a motion.
So moved.
Moved by Supervisor Mills,
Second.
second by Supervisor Garamendi. No further public comment. All in favor indicate by saying aye. Aye. Opposed indicate by saying no. Hearing none, motion carries 5-0 unanimous.
Supervisor announcements. In compliance with AB 1234, chaptered as
On what?
George Fry.
George, what's your public comment about?
Gentlemen, the 29th of September is the last day to pick a senior citizen in your district for the senior citizen of the year.
George, I'm going to cut you short here. We've all received that email.
Okay.
All right, we're all aware of that.
I'm just wanting to remind you.
Okay, thank you.
Number two, next Tuesday.
George, this is not public comment.
Yes, it is.
No, it is not. It is reporting out.
Just for clarification purposes, the general public comment that we had this morning, we didn't finish. We stopped at the 30-minute mark, so we do open general public comment
George.
back up at the end of the meeting.
I apologize.
I only waited from
It's been a long, long day.
9:30 this morning until 9:30 tonight.
Okay, all right.
Next item. Tuesday night, the 29th, the night meeting, I will be bringing a public comment about Pogo, the cartoon.
Okay. George, thank you. I apologize.
Night, George.
Oh, I was just going to suggest, regarding late nights, why don't you have weekly meetings and cut these meetings in half? I mean, these 12-hour meetings, it's tough on everybody. It's tough on you, it's tough on everybody. Maybe the agenda should be, put together so the meeting won't last more than 8 hours, 6 hours. Just a suggestion. Thanks.
Thank you. I'm sorry, Madam Clerk, you can continue. I think I interrupted you. Public comment.
Good evening. I just wanted to remind, I wish I could have done it earlier when more staff was here, to use your microphones. It's really hard to hear you out there or when I'm at home trying to review these meetings. Thank you.
Thank you. We'll try it one more time, okay?
Okay, supervisor announcements. In compliance with AB 1234, chaptered as Government Code Section 53232.3D, this is the time for board members to report on meetings attended on behalf of the county and to carry out their duties as a county supervisor.
Would you like to start, Supervisor Clapp?
I might as well. Anyway, I have the unfortunate duty to report out that Marge Warner, that was on an advisory committee for Area 12, passed away. I'll be at her funeral on August 26th at 2 o'clock. It'll be in Sonora. September 1st, Supervisor Tofanelli and myself, along with some other people, will be, and Rancho Road Committee will be having an open house at Ginland Fire, and that'll be at 6 to 8. And if you're coming there to talk about cannabis, you hit the wrong meeting.
Okay, thank you. Supervisor Mills?
I'm going to forego my AB 1234 for another day. I think that ought to be the best gift I give you today. But I do want to ask for the board to consider an appointment to the Eastern Groundwater Basin Authority. That is critical. It's coming up, and we've got to get somebody appointed to be on that committee. Thank you.
Supervisor Tofanelli?
I would forgo. I'm tired, so I forgo my AB 1234 too.
Supervisor Garamendi?
I will forego, but I will notify everybody that on Saturday, they're having the fundraiser at Mountain Ranch Community Park. I will be serving in the dunk tank at 12 noon, and all you, my fellow supervisors, are invited to join me. There is no dignified way to do this activity, but if you show up, I'm sure we could raise a lot of money for Mountain Ranch Community Park. 11 throw baseballs.
Supervisor, I was a softball pitcher.
You're welcome to come up to this, but if you're going to throw, you got to sit in the tank too.
Okay.
Thank you.
Thank you.
Ladies and gentlemen, I'm going to be very brief also. On the 9th, I attended the local tree mortality task force meeting here in Calaveras. I also attended on the 10th the American Legion luncheon with Supervisor Mills, and we were able to attend the Calaveras County Taxpayer Barbecue, which I presented the award to Ed Lark, our PATV department head. And attended the Governor's Task Force in Sacramento on Monday, on the 14th. Was able to attend our, once again, Board of Supervisors and Admin Strategy Planning meeting at Ironstone, which I thought was very, very effective. Not only for the Board of Supervisors, we were able to meet with department heads, and I think that was very productive, and I'm looking to see how the results of that's going to play out. I attended the Chamber of Commerce mixers at Murphy's Park. What I'd like to comment, and I'm doing this for the television, the folks at Chamber, and they've done just an outstanding job. Another group that did an outstanding job is our Spirit Committee today for the Ice Cream Social. I must apologize. I should have mentioned this earlier. Someone shaking her head at me.
No, I'm sorry,
Hang
it
on.
wasn't the Spirit Committee, it was the department heads. That, today's event was sponsored by the department heads.
I stand corrected. It was department heads, and they served 3 types of ice cream. And I have to be honest, the decision on what types of ice cream was a very heated discussion at our board agenda meeting, but we came up with a good, solid decision. So, having that said, we will be having an agenda review meeting tomorrow. Our next meeting, Tuesday, the 29th at 6 p.m. It will be a night meeting. So, ladies and gentlemen, thank you for attending. Meeting's adjourned.